I had to do it. Like, people hate when I hit that button, but your girl is back. Okay, I'm back. I had to take a little bit of time off for some personal things, but guess what, chat? This week is the start of the Julio Foolio trial. I'm so excited. We're going to hope and pray that this trial does not get moved because you guys know how it is. Like, it happens. I was so pumped for Courtney Clenny was literally this close to booking a ticket to report on the trial live from Miami. And they were like, oh, April 27th is now moved to August. I was like, damn it. I would have lost some funds. Okay. But from what I can see, I was in the case file about an hour ago. This is looking really, really real. And that means whatever happens this month, Alicia Andrews will follow, likely in May. So here's the status. There was a hearing last week. I have not seen it. We're going to watch it together right now, dear viewer. So we're going to watch it together right now. It's one of the very last hearings. The trial is scheduled for Wednesday. And Judge Sisco did say that they are going to take 2 days for jury selection. And then it's time to rock and roll. The four boys, it's time. It is time. So we are back, guys. We got a trial for the next, I'm going to ballpark it, 2.5 weeks. Judge Sisco likes to deliver a jury a trial in 7 days. We'll see how these boys do. But as far as today, let us take a look at the hearing, see what happened, get completely caught up, and then start to talk about what this trial looks like. It's very unique. We haven't seen something like this in, I would say, 2 years, where the YSL trial is probably the last time we watched a trial together with multiple defendants. This is going to be 4 of them. Now, one thing you should note, you see the thumbnail, Rashad's eyes are big. They're bulgy. Why? Because also while I was gone last week, he filed a motion to sever from the other 3 defendants. Judge Sisco said, nah, she back on her bullshit. She's back. I can't wait. So I think that this is going to be one of the most eventful trials of the year. Y'all know me and my team are catching up. We're working. There's many stories you want us to cover. We just did an update on Fulton County. We got another one on Tiffany Henyard tomorrow. And you bet your ass I am looking at that Pooh Shiesty situation. Okay, we are looking at that too. So much to catch up on. I'm happy that all y'all are back. Do me a favor, hit the like button. We're here all week. New merch is coming. I don't recall is up, but new merch is coming for the Foolio case. And I will also reach out to Foolio's mom to see if she's still down to come on the channel. And if this trial starts, I guarantee she will likely be in the room. That being said, why don't we jump on into last week's hearing? Okay, it's about an hour and a half. So we'll be here for about 2 hours, chat, and see what is happening. Let me boost the audio. You guys know with these courtroom audios, it can always be finicky. So I'll try to balance it as much as possible. Let's hit play and put the captions on and let's go.
No, they're in the office there, either on the desk or in my purse on the interior pocket. Thanks. I set him down, and I'm like, yeah, I can't see.
One other important thing to note is Judge Sisco here is presiding over the case. So even though she was taken off of Alicia's case, she is still going to be judging over the boys.
Okay. So I have reviewed the following motions. Isaiah Chance has a motion in limine, and the state filed a motion to compel disclosure of raw data generated during administration of tests for a number of the defendants. And then Rashad Murphy filed a defendant 6 motion in limine as to Robert Howard. Are there any other motions that we need to hear today other than those 3?
Judge, I believe Mr. Harmon filed yesterday a motion for order in limine having to do with the verdict of Alicia Andrews. Did you receive that?
I don't believe that I did.
I believe it was filed yesterday.
That's a big one. So they don't want the verdict of Alicia Andrews to be. This is gonna be a good trial, chat. I can see it.
I thought we discussed that already, but
We did briefly, Judge, and I think that's why Mr. Harmon filed the motion.
okay. Yeah, and I indicated that it was certainly not relevant during guilt phase.
And so this has to do with penalty phase.
Okay, well, I don't know. So, all right, I haven't reviewed it yet, so I'll take a chance and take a look at it. Take a second and look at it after we do these. Okay, y'all care which ones we start with?
Judge, I think Ms. Isburn was hopeful that we could do Mr. Howard's motion in limine last.
Okay, sure. All right, so why don't we start with the state's motion to compel disclosure of raw data generated during administration of tests. And I have a motion filed as to Rashad Murphy, Davion Murphy, and Isaiah Chance.
Very, very quickly, just for the record, Christopher Delauder is going to be sitting in. He is a certified second phase attorney. He wants to get some experience on first phase, so he will be sitting in with myself.
For the remainder of the trial or just today?
That's correct. As much as he can. Really
Sure. That's fine.
I just want the court to be aware of that.
Yes, thank you. Good morning. Okay, so those are the three defendants. Did Mr. Gathright, do you have one as to Mr. Gathright or no?
No, Judge, these were, it's my understanding from Mr. Harmon, these were the only three defendants that had mental health experts in this area.
Okay, so Mr. Gonzalez, as to Rashad Murphy, do you object?
Judge, I think that would be.
Oh, I'm sorry, Mr. Hernandez, do you object?
What motion is this?
It's the state's motion to compel disclosure of raw data generated during administration of
No,
tests.
Your Honor. Obviously, that is done directly from one doctor to the other. We don't get involved in it, but I can contact my doctor and it gets sent directly to the state's doctor.
Okay, and obviously, and I don't know, only you know, in the raw data, your expert may know, if there's anything in there where the defendant spoke about the facts of the case or defense strategy, then obviously that data does not have to be disclosed to the state.
I would have to check with the doctor, but based on the deposition that was taken last week, I think that that's not going to be an issue because in response to one of the questions, my doctor indicated that the defendant had not discussed.
That's a new attorney. Who's that? Is he okay? Rashad might have somebody on his side.
Whether any issues regarding guilt or anything. So I don't think that's an issue, but I would have to double check with the doctor.
Okay, well, just make sure that they know before the data is conveyed to the state that if there is anything in there that that can be redacted or withheld, but you just need to, essentially, what I would need the doctor or you to do is to make some type of privilege log, just so it's reflected that this is what we held back and this is why. And then if there is a finding of guilt as to first-degree murder, and if we're going into a penalty phase, then potentially that material would have to be disclosed, but we can discuss that if we get there.
If once the state can provide me an email for the doctor, I will reach out to my doctor to have send with the court's instructions.
Okay?
That's fine, Judge.
Okay, very good. All right, so as to Mr. Sonardi, as to Davion Murphy, do you object to the motion?
Yes.
Or, go ahead.
Yes, correct. To the state's motion you're referencing?
Yes.
Yes,
Okay, just, you don't think any raw data should be at this point disclosed?
correct,
Based upon what?
correct.
No, what is your argument? What's it based upon?
I'll just adopt the other co-defendant's arguments as to that.
Okay. Okay, so I'm going to grant the motion with the same exceptions. Mr. Sonardi, you just need to confirm with your expert that they are to supply the raw data you get the information regarding the state's expert. However, if during the interview of Mr. Davion Murphy, if he made any statements regarding the facts of this case or any defense strategy, then those statements or that data does not have to be transmitted, but you do have to create a privilege log if you're holding it back. Okay? All right, and finally, as to Mr. Isaiah Chance, Mr. Petratus.
We would object, I spoke to our doctor, and her concern was that the state's doctor is a psychiatrist, not a psychologist, would not have been trained in the test that she administered. Said that Mr. Chance, based on that.
Okay, well, that sounds like a jury issue, potentially, cross-examination or direct examination issue. So I'm going to grant the motion. Again, Mr. Petratus, the same thing. If there is anything contained in the raw data regarding defendant statements as to the facts of this case or as to any defense strategy, that does not need to be conveyed to the state's expert, but you would need to create a privilege log. Okay? All right, very good. All right, so Mr. Chance's motion in limine.
Okay, so Isaiah is up first. Thank you for everybody that is popping in, showing your memberships. What I will do is the last stream, I had to cut it short with Afro Man. So I'm going to give away 2 t-shirts. Okay, 2 t-shirts today. So stick around, stay in chat, hang out. You might be one of the 2 lucky winners. Isaiah Chance is the first motion up. Isaiah is Alicia's baby daddy. Okay, does he have a new neck tattoo?
And state, do you object to this motion?
Yes, Your Honor, the state this morning filed a response with its motion limiting that was filed yesterday, provided courtesy copies via email to the court and provided physical copies to the defense attorneys as well as the courtesy email this morning. We included the argument from Mr. Petratus as well as the argument on behalf of Davion Murphy for the YouTube videos that were listed. Mr. Petratus.
Well, this is all I've got. This is all I've got. Mr. Chance filed a motion in limine and wishes to have excluded any allegation, mention, inference, or indication, whether through witness testimony, picture, video, or attorney statements to the jury of music video or stills from the video, quote, blood on my Pradas, close quote, by Isaiah Chance. Said video has no direct connection to the murder of Charles Jones and has imagery, firearms, dead body, etc., that would be unduly prejudicial without any probative values. That's what I'm referring to.
Yes, Your Honor.
Okay, so you're objecting to that.
Yes, Your Honor.
And what's the basis of the objection?
The evidence, there is items or are items of evidentiary value contained within that YouTube video presented at the state's evidence view. The state did decide to utilize screenshots in lieu of the video itself. Those screenshots depict the defendant only, not the dead bodies in his videos and all of the violence from the videos. We actually limited the exhibit itself to several screenshots, well, many of which prove up elements that are required for the gang concept.
Okay. And what's your response to that, Mr. Petratus?
Not withdrawing my previous objection to the gang.
Right.
But if it's just photos of him with the, I assume the 23 chain, stuff like that.
Do you have the still shots here?
Yes, I presented these still shots we used at trial at the evidence view to defense.
Okay.
I have them electronically as well on my computer. Your Honor, I can pull them up if necessary.
I have the 3 photos, I believe. 2 of them just Mr. Chance with a 23 chain. There's no other imagery that we would object to. The other issue is, though, the name of the video is one of the pictures, and I would object to the name of the video.
Okay. What's your response to that?
The state, in admitting the evidence, is proving the authentication of the video and the source from which the video derives. So identification of the defendant, number one, given that the subscriber information records linked to this defendant, the title that's used or the name that is used by the defendant is not his legal name. So it's more than just authenticating the video, but also identifying the defendant for purposes of this exhibit.
Okay, for record purposes, we probably need to identify exactly what it is we're talking about. Can you either display it so I can see it and Mr. Petratus can see it, or you can?
Yes, Your Honor.
What's happening?
Also, while you're doing that, we had a superseding indictment, correct?
Judge, that is correct. The only thing that has changed is count 2, which is the conspiracy count. We expanded the time frame of the conspiracy back to June 6th of 2024. That's the only change to the indictment.
Okay, Mr. Gonzalez, on behalf of Rashad Murphy, how does your client plead?
We would plead not guilty, Your Honor.
Okay, Mr. Sonardi, on behalf of Davion Murphy, how does your client plead?
These boys, okay, here are the pleadings. The first one was not guilty. These boys sprayed up, Deonra. They sprayed up and got caught on Tesla footage, okay? The first one said not guilty. The second one's about to say not guilty. If we get not guilties across the board, chat, my word. Let me go back 10 seconds so we could hear it again for the cheap seats in the back.
24. That's the only change to the indictment.
Okay, Mr. Gonzalez, on behalf of Rashad Murphy, how does your client plead?
We would plead not guilty, Your Honor.
Okay, Mr. Sonardi, on behalf of Davion Murphy, how does your client plead?
Not guilty.
All right, Mr. Wise, on behalf of Mr. Gathright, how does your client plead?
Not guilty.
All right, and finally, Mr. Petratus, on behalf of Mr. Chance, how does your client plead? Okay, very good, thank you.
That's not guilty on the conspiracy charge. So they updated the indictment. I will bring you guys up to speed. Don't worry. We got a video come in before the first day of trial.
And while we're waiting on Ms. Ismer, let's just talk a little bit about jury selection, okay? So while I spoke with jury services and they're summoning enough people, they hope, to at least get 150 in here, okay, 150 people. Actually, let me back up. We're not doing jury selection in this courtroom, okay? So we're doing it in courtroom 1. So we have, just because I'm going to need to be able to utilize the lobby outside to seat people, and there's no lobby outside of this courtroom that would be large enough to accommodate 150 people. So we're going to do all of the jury selection in courtroom 1. We're going to try the case in here. All right. So I know we can get 150 in the audience on the benches. My bailiffs also determined that we could get an additional 25 in the jury box with some chairs in front. So conceivably, if 175 people show up, we can get 175 in courtroom 1. My inclination is if we have the space and we have the people, we should just bring them in. So that's my initial thought on that, is that it actually would be 175 people, assuming we get 175, Wednesday, Thursday, Friday. So then my question to you all is, as far as numbering them, my inclination is to do 1 through 150, like normal, like what I normally do in the audience, in the benches. And then do 151 through 175 would be on the side where the jury box is. And remind me, Ron, Reggie, how many chairs do we have to put in the front?
In the jury box?
Yeah, outside the jury box.
7, 6, 6, 6.
Okay. So what I will do is I will have my JA come up with just a general seating chart.
Hello, ear rape.
So you know the numbers of where the people are going to be. All right. And then starting the next day, then we would start with 176, put 150 out there. And then if we get the extra 25, again, put them on the side, and the same thing with Friday. All right. So I will do seating charts for you all with that anticipation, and you can at least use that. Okay.
Law and crime did us dirty with
I suspect a lot of
Law and crime better not pull this shit next week. Oh my God. That hurt.
individual work on. How do you plan? to do
So
that?
this is what we do. With regards to this first round, and I think we discussed this before, but you may not have been here with Mr. Hernandez. So how this is going to work is phase 1 is going to be questioning with the jurors about hardship and whether or not they can serve, and then pretrial publicity. So what I'll do is, when we get the list of 175 names, all you all are to do is simply write down the name and the number. That's it. Don't start looking at slips. We're just get down the name and the number. I will give my introductory speech that I do in all death penalty cases. Plus, I normally don't instruct them on the death penalty at this phase. However, in this case, I am going to give a preliminary instruction because, unlike my normal practice, I am going to break down the people that can serve into smaller groups for death penalty voir dire. And the initial instruction on those jurors normally takes a while because I know I have a long speech I have to give. The state normally gives a relatively long speech, and then the defendants can give whatever speech they would like to. And I don't want to have to repeat that every morning during voir dire of the penalty phase, which would be phase 2, because it just sucks up time. So I'm going to give my preliminary instruction on the death penalty. I will then allow the state to give a preliminary instruction. You all can give a preliminary statement if you wish. And then what I will do is I will then ask the jurors 2 separate questions. I'm going to ask them first to raise their hand if they're going to claim a hardship for while they cannot serve. And then I'm going to read a statement, and I need to get an agreed to factual basis from you all to read to the jury and ask them if they think they know anything about this case. I will probably, so for those individuals that raise their hand as to knowledge about the case, pre-trial publicity, I will do individual voir dire, and we'll do that first. We'll bring them in one at a time. For those that are claiming a hardship without pre-trial publicity, I will do those in groups. So I'll bring them in, probably have enough to seat in the first row of the audience, and then I will ask them the initial question as far as what their purported hardship is. And then I will allow each of you, if you wish, to do any follow-up questions.
So this is actually interesting, guys. This process is starting on Wednesday. So what Judge Sisco is talking about is they're going to begin jury selection and start picking from a pool of about 150 people. Those people are all scheduled to arrive in the courthouse on Wednesday. And then Thursday and Friday, they're going to go through a process to eliminate them to get to the final jury. Now, I want to see what she says because there's 4 defendants here. And if she wants to complete this process by Friday, the official trial start date, although they start jury selection, which is a part of the trial, we might hear opening arguments on Monday morning. Okay, so I am clearing my entire schedule to focus on this case, especially because we all saw Alicia Andrews. We all saw the sentencing get delayed. Judge Sisco, this exact judge right here, was removed from sentencing Alicia. And right now, Alicia's next court date is in May. So the fate of these 4 boys, 3 of which are facing the death penalty, begins this week. So she's walking you through the process. If you guys have ever been through jury selection, then you know what the process is. You can opt out for certain reasons, like if you don't believe in the legal system and things like that, if you're concerned about trial publicity, but that is what we're watching right now. And Judge Sisco is agreeing to what that process is going to be starting this Wednesday. Got a nice view of Isaiah Chance there because I can't wait to see his mama back on the stand. Isaiah's mama got him in trouble last time with Alicia's case. So let's see what happens this go round. Let's go back in.
And then once all of those individuals have been questioned, then we will determine who can be excused. And at the outset, just so you know, I will excuse people for cause at mostly at lunchtime and at the end of the day, but only if everyone agrees. So if anyone objects, either the state or any of the defendants, to any of the prospective jurors being excused for cause at that juncture, I'm going to leave the person in the pool. So because you may want to rehabilitate them, I don't know. Okay. So the individuals who do not raise their hand at all, who don't know anything about the case and who are not claiming a hardship, they will be excused until Monday. And then they will come back to begin the first smaller group for death penalty questioning, which is phase 2. So my goal is to hopefully have smaller panels of 30 to 40 people just for death penalty voir dire the following week, which would be Monday through Friday. And then once that is finished, then the following week, Monday and Tuesday, will be general voir dire for those that remain. All right. So I am well aware of the number of peremptories, 40 total for defense, 40 for the state. So I'm hopeful that we will have, at least 150 come back for the final phase. We'll see. So this is just going to be a situation where as we go along, we will see how things are going. All right. So then if I get, let's say, more than 30 people who can come back the week 2, I'll push some to Tuesday. And then same thing, Thursday people will come back either Tuesday, Wednesday. Friday people that come back will come back Thursday or Friday. I won't know until I know what the numbers are, exactly what day they're going to come back. But just so you all know, it will be smaller panels, week 2, 30 to 40, just on death penalty. Okay. So Mr. Hernandez, is that a long-winded way of answering your question? Okay.
Judge, one question I have.
Sure.
The statement that the court's going to allow defense and state to make after your initial inquiries, what is the court anticipating with regard to that statement?
I'm assuming it's just pretty generic, just enough to trigger their memories. We had a statement in the Alicia Andrews case that you all may or may not agree to, but it's kind of just basic parameters, things like that this was a shooting that occurred up near USF on the date in question, and that it involved an allegation of potential gang involvement, and the victim was Charles Jones, known by his rapper name Julio Foolio, something like that.
And that's the statement that's going to be given by the court.
Correct.
What about the statement that you're referring to that you would allow both the state and defendant?
That is the statement. No. The statement
I'm
that
talking about something that we are allowed to get up and do with that.
Yeah, no. No. There's 2 separate, I guess, statements. So the first one is the one I would make in anticipation of my question about pretrial publicity. Okay. The next would be with regards to the death penalty information. And again, just from experience, Mr. Harmon has a script that he uses, and I don't believe in any of the cases I've done, defense actually said anything in addition, really. So you don't have to. I'm just letting you know that if you would like to stand up and just give because I'm allowing the state the chance to do it, to give a general instruction or information about death penalty qualification.
Fine, Judge. I need some clarity.
Yeah, it's just, I don't think any defense attorney has ever done it, and you don't have to. I'm just giving you the opportunity if you so wish.
Understood.
Okay, but normally between myself and Mr. Harmon, we cover pretty much everything. So, okay. And I'm also considering, and you guys tell me if you think it's a good idea or a bad idea. Once we get our jury picked, so this would not include next week, I'm considering giving the jury Fridays off. Mr. Sonardi gave me the thumbs up. What do you guys?
That's different. So with the Alicia Andrews case, she wanted to give it to the jury in 7 days. This time she is considering giving the jury Fridays off. Because there are 4 defendants, I think that might mean that we might be here a while.
I'm hoping that will be some sweetener to encourage people to want to volunteer to serve, since they know they at least will get Fridays off to handle their personal affairs or do what they need to do. But you all tell me.
Certainly always a good situation with regard to getting people to want to serve, and certainly allowing lawyers to do what they do. I don't know if the state has any indication. We haven't gotten a final witness list yet, which of course no one's obligated to do.
Right.
But to the extent, would the state have any indication as to what they think their case in chief, short of a catastrophe, might take? I'm just more looking about, quite frankly, Judge, my calendar beyond
Sure.
15th. And there are some challenges there, and I need to know whether the state has any idea as to what they might.
So
do.
let me ask you this. So let's just talk about this a little bit. So hopefully if everything goes smoothly, jury selection will be concluded by Tuesday, April 21st. Okay, that's my goal. I will be working very hard towards that goal.
She wants to finish it by April 21st. We're going to be in jury selection for 2 weeks. Whoa.
That means we do opening statements on the 22nd and begin with the presentation of the evidence, the 22nd and the 23rd. I can tell you right now, we will not have court on the 24th of April. So then the guilt phase portion would begin again April 27th. And we'd go through that week. And then depending upon things and depending upon if there's a finding of guilt as to first degree murder, penalty phase would begin May 4th or thereafter.
Jesus. Okay, chat. All right. I'm letting her talk through her calendar, but I'm also pulling up a calendar. This trial officially begins on Wednesday. She's saying, and she wanted to, remember, we just talked about it. She wanted to give the jury members Fridays off. Because there are 4 defendants, and they were talking about this, I need to clarify if there's going to be 4 separate juries, and that's why it's taken so long. But she is seeing, so we're going to start this week on selecting jury members, only from a pool of 150. And she wants to begin presentation of evidence on the 21st. And then this is the same shit she did with Alicia. So I got a calendar right here. We're looking at it. So if we begin opening statements on the 21st, this is the same thing she did with Alicia. She said that people would have it on Halloween. They would have the case and they'd be ready to deliberate, right? She's saying on May 4th, they would talk about what the sentencing looks like. So these next 3 to 4 weeks for these young men are so crucial because 3 of them are facing the death penalty. So what that means, and what we're looking at here, is it looks like she's giving 2 weeks for jury selection, right? To start on the 21st. And then that's 1, 2, 3, with Fridays off, 4, 5, 6, 7. 7 days of trial. Oh, shit. She's only going to give them 7 days to present their cases?
And last most of that week.
Does that comport potentially with what the state would anticipate from a case in chief standpoint? And again, I'm asking a question that they may not have the answer to, Judge. I'm just inquiring.
I think that in general terms it does. I know that this trial will be somewhat longer because there's more attorneys, but
Sure.
I think that that's a good general guideline.
So I'm trying to remember how many days did it take us in the Andrews case? 7? Well, remember we picked a jury though.
Correct.
Starting, I can't remember, did we start Wednesday or Monday? I think it was Monday. Did we start Monday?
Judge, I don't know.
Yeah, I don't
I'll have to go back and
know
look.
either. Let me look. I don't know. What month even was that? Who
I
could
know
even?
It came in on October, on Halloween.
Okay, let me look.
5 years ago now?
Yeah, it feels like it. Yes, it was. Yes, it was. Okay, well, I don't have that with me. So anyway,
That gives me a much better indication, Judge, without nailing anybody down, that actually answers my inquiry.
yeah, it took us a couple days to pick the jury in that case. It took, 2 to 3 days to get the jury picked. So it took us, I'm going to say, about 7 work days to get it tried. So maybe 8 or 9, just because we have more lawyers, but I would say 8 or 9 for guilt phase portion of.
They are cooked. Let me vote. Let me vote myself. I have a poll up right now. Are these boys cooked? I'm going to vote myself for yes at 87%. All of you guys vote in the chat right now. She's only going to give 9 days before this goes to the jury for deliberation. But this is the shit that happened in Alicia's case. This is the same shit.
The trial.
There may be a few more witnesses in this case.
Okay. Okay.
And probably a little more extensive testimony from those witnesses, because I think there were some limitations.
Sure.
In Andrew's case that probably don't exist here.
Sure. Okay. So, yes.
I guess along those lines, I think it's safe to say that I should, if there is a need for a penalty phase, I shouldn't have any witnesses ready in April. It should be May.
Yeah, it'd be May. I would say May 4th at the earliest. May 4th at the earliest. And I'm going to ask Mr. Hernandez, what's your absolute need to be done by date? Mr. Gonzalez, what's your absolute, and Mr. Hernandez, what's your absolute need to be done by date?
Judge, preferably the 18th or 19th of May. I don't know whether any of those days fall on the weekend, but.
Yeah, we'll be done by then. Okay. Mr. Sonardi, what about you? Any?
Fine.
Now she's asking the lawyers, hey, what's your drop dead date that you need to be done? And he's like, oh, the 18th or the 19th. She said, we gonna be done by then. Damn! She said, we'll be done by then.
Okay. Mr. Wise?
Your Honor, my only, sounds like I'm on the same boat as Mr. Gonzalez. I had everything blocked off through May 15th, so starting May 18th, I have.
Yeah, we'll be done by then. We'll be done by May 15th. Okay, we will. And Ms. Petratus? Okay.
She just said it to the other attorney too. Oh, I need to be done by May 8th. We'll be done by then. We'll be done by the 15th. She wants this shit done in 7 days. Alicia got 7, they getting 8. Oh, word. This is going to be interesting.
Yeah, we will. So, okay. Very good. So now that we've discussed the calendar, so at this,
Did you see Isaiah and the other one lean back at the same time? They said, oh shit, she's just gonna try it. It's not funny. It's not funny. But this is, they both leaned back. Hold on, let me do that one more time. Let's go back 10 seconds. You see how they're both leaning forward? Watch this, chat. Watch this.
very good. So now that we've discussed the calendar, so at this point,
Damn!
I won't commit to the jury taking Fridays off. I will tell them Friday, April 24th for sure. And that if we're making good progress and it looks like I can give them a Friday off, then I will. But at this point, I'm going to be conservative because it's more important that we, the trial gets completed in a timely fashion. So, okay. Okay, Ms. Ismer.
I don't know, TT. She about to retire.
Yeah, the signature, I need to help these guys. That's what it looks like. And Connie made that sheet in the back. Want me to just make a copy and give it?
That'd be great. Excellent. Okay, so this would be, the state is displaying, this is a still shot, blood on my Pradas.
Oh, here's Isaiah's video.
And that is Goudaze.
Goudaze.
I believe is a name that Mr. Chan.
She said Goudaze. This is going to be an amazing trial if she's calling him Goudaze.
This goes by correct.
Yes, sir.
Okay, and when was this distributed or?
I'd have to look back at the.
Blood on my Pradas.
date.
Okay, or posted.
Gouda Zay,
September 2023.
I
Okay,
think the 8th.
Alicia's baby daddy.
okay. So this is the one you object to,
This specific picture.
this specific
And
picture.
I'll say, we're not gonna be objecting to Detective Leader or someone who knows him saying that that is Mr. Chance. And we're not gonna be objecting, that is the name, the top gonna say that he uses. But I don't, so, and we're not gonna be objecting to this, but based on your ruling, the other two pictures, which is him wearing a 23 chain, not
Okay.
shown in this picture. So I'm not gonna object to this and then try to jam up the state later, but it's this specific picture, I don't think it's necessary to show blood on my product.
Well, yeah, so what if they just redacted blood on my Pradas?
Well, I would say that, what he's doing in that picture could be interpreted negatively. Whereas they're just trying to show him wearing the 23 chain in a music video. I don't want to say stipulate, but I'm not going to object to suggesting this was a video he made on September 8th, 2023. That is Mr. Chance, and he's wearing, it can be very obvious in the other two pictures, a chain, number 23 on it.
Yeah, well, it looks like, just for the record, it looks like he's maybe mimicking shooting a gun or shotgun or something. That's what he appears to be doing. So why do you need the title "Blood on My Pradas"?
All of the other exhibits from YouTube include the title and the account name for the individual who posted them. So to redact only this screenshot or only this defendant's music video, which indicates obviously still images for at least this exhibit of the defendant wearing his gang chains or talking about offenses or crimes that are linked back to the gang that he's affiliated with, I think it causes a discrepancy in what evidence is being presented. The defendant would, in this instance, be the only person whose music video title isn't also displayed alongside of all of the other videos, which are.
The redhead is gonna piss Isaiah off. I could see it. I could see it right now. I could see it. Isaiah's like, nah, blood on my Pradas, leave it.
Establishing his gang enhancement.
All right, let me see the other still shots, just to make sure, for the record.
This is still shot 1. And still shot number 2. Both have been redacted to remove the guns or body parts that were depicted.
Okay. And this is going towards the gang enhancement, correct?
That's correct, Your Honor.
Okay.
We'll seek testimony as to the lyrics because in playing the video, obviously, we knew the defense would have an objection to all of the content, which is why we've redacted to these specific images.
Okay, very good. All right. So based upon the state stipulation to limit this exhibit to the 3 screenshots, I'm going to overrule or deny the motion in limine, followed by Isaiah Chance. I find that the evidence the state seeks to admit that its probative value outweighs any prejudicial effect.
Okay, first loss of the day. All of those pictures, those 3 pictures, it's 3 on her computer, but we just saw 2. So that first photo and that second photo are coming in. So I say it just lost.
Okay, and next would be the motions I have a copy of. Defendant Rashad Murphy's motion limiting as to Robert Howard.
Okay, this is big. Y'all remember Robert Howard?
Judge, this is an all-encompassing motion, as the court can see, regarding several different areas. And it is buttressed on the statement provided and ultimately made confidential, made by Mr. Howard in August of 2025, as well as his deposition taken on February 4th, 2026. It seeks to limit, based on what I believe is hearsay, improper speculation by Mr. Howard, and pre-conspiratorial statements that are attributed to other defendants. Certainly understanding the court's ruling with regard to severance, I still have concerns about evidence that may in fact be admissible against one defendant and not admissible against others. As it relates to the hearsay statements, Your Honor, any statements that Mr. Howard alleges Mr. Murphy made as it relates to threats to him or his family are statements that he heard from other individuals. And that's based on his testimony at both his statement and his deposition. He talks about things allegedly stated by Mr. Murphy that were told to him by others, and goes on to suggest that in his alleged conversations with Mr. Murphy on multiple occasions, he didn't consider those conversations either threatening nor friendly. So certainly buttressing that feeling and that speculation and that statement being what he's been told by others.
Okay, so maybe it'd be helpful if we just went through these statements. You've broken out the different statements per category, right?
Yes, Judge.
So let's just start with the hearsay statements, beginning at page 2 of your motion. Specifically, you allege.
All right. So now we're getting to the core of the argument here. And the core of the argument is, you guys know, we've talked about this a lot on this channel, is understanding hearsay. Hearsay is a third-hand statement. That means somebody told me that this person said this. It's not evidence. So in the world of evidentiary law, it's something that has, I think, almost like 20 exceptions on when it could come in as evidence. Now, the reason why this is important is because Robert Howard testified in Alicia's trial, and he said some things. And y'all remember, Jeremy was trying to get him in, and he's like, no, I don't want to testify in that trial, so it's a big deal. There are some statements that are made. Let's hear how the attorneys do this out.
That Mr. Howard testified that he heard from other individuals that Murphy had made threats.
That's correct.
Okay. State, were you intending to elicit that from any Mr. Howard?
Is this as to paragraph number 5, Your Honor?
It is.
No objection as to statements you heard from other individuals, only statements that Mr. Howard heard directly from Rashad Murphy would be suffered.
Okay, so as to paragraph 5, it's granted. And then paragraph 6, Mr. Howard further clarified that he spoke with Rashad Murphy on multiple occasions. Oh, so that's
just
different.
providing
Yeah.
context.
Okay. And then the next would be paragraph 7. Mr. Howard testified, subparagraph A, that he communicated with Isaiah Chance, who told him that Murphy was hot about Adam's murder. State, are you seeking to elicit this from Mr. Howard?
Yes, Your Honor. Any statements that were made by any unaffiliated party with the case, the victim, as listed in this motion, the state's not seeking to introduce. But statements made by the defendant or co-defendants in this case, the state is seeking to introduce. Not as statements of hearsay, they're not being offered for their truth, but to establish intent and premeditation and motive in this case.
Okay.
Judge, it also goes to admissibility statements as it relates to Mr. Murphy. And the argument would be it's not a co-conspirator statement based on when it is said. And in fact, I think the state would have to establish when that statement was made to determine whether or not it was in the course or in furtherance of any conspiracy. And I don't think they can do that.
So state what your argument is as far as why this is admissible if the statement was made not during the timeframes of the purported conspiracy.
Because Mr. Gonzalez's argument reverts back to a co-conspirator admission, which is a hearsay exception. The state's position is that it's not being offered as hearsay. So understanding the limitations of a co-conspirator hearsay statement, we're not offering it as a statement of hearsay in the case. It is strictly being offered as proof of other elements, so knowledge, intent, premeditation. The state has filed in its initial response to the court and had previously provided to the court the case law on this before Mr. Gonzalez's motion. So the March 5th response gave the case law for all of the reasons that the state sought to introduce each of these statements, Your Honor, and we would rely on that case.
Okay, I'll come back.
Judge, Mr. Howard can't testify to what Mr. Chance told him about Mr. Murphy. And I don't think it's admissible based on any theory of motive.
Isn't it double hearsay?
Yeah. And all the defendants are in the room.
That Mr. Murphy was hot are statements that are made from Mr. Chance to Robert Howard telephonically. Is that what are these the ones you're referring to, Mr. Rizal?
Yes.
And so the state's not off, again, the state would just reserve the same exact basis as for why the evidence is being offered. It's not being offered for its truth. So continuing to indicate that because it's an out-of-court statement, it invokes co-conspirator hearsay when the basis for why the state is offering the item of evidence is strictly the defendant's knowledge of what was to occur, the premeditation of the act of what is to occur, because the context of that conversation is in telling the person listening, which is the witness, Mr. Howard, to be careful, essentially, when he goes to Tampa. These things are in context being offered for a different purpose than a hearsay or co-conspirator statement or admission.
Let me think about it. Okay, the next one, subparagraph B of 7, Howard testified that Charles Jones told him to watch out for Murphy because of Murphy's purported threats.
No objection from the state.
Okay, that one's granted. Subsection C of paragraph 7, Howard testified that he heard rumors that Murphy was riding past the prison that Howard was at.
No objection from the state.
Okay, granted as to 7C. Okay.
Hollywood.
So I think that takes care of all of the statements identified in your subsection under hearsay. Is that correct?
That's correct.
Okay, moving on to opinion, speculation, beginning at page 3, paragraph 13. Howard testified about a Bill Belichick and Tom Brady social media post, which he attributed to Isaiah Chance following the murder. Howard speculated that the post referred to Charles Jones because Brady is the GOAT of football and Charles Jones is the GOAT of rap music. State.
The witness's impression or his specific observations, I don't expect he'll be testifying about what Isaiah Chance meant, but only about what he understood the post to be.
Judge, I think that's inadmissible. It's asking Mr. Howard to speculate and give his opinion as to what he thinks something might mean.
Well, what was the
Not an
actual?
expert.
Yeah, what was the actual? What was it that was posted, and
Now
what was the
show.
content of the post?
A photo.
We saw this in the Alicia Andrews trial. What they're talking about is when they were talking about all the back and forth posts, the back and forth between Julio and these boys, right? So apparently Isaiah had posted a picture of Tom Brady and Bill Belichick. And, again, you guys all know how this is connected to the whole Young and Ace thing. But Isaiah had posted that the day after Julio was murdered. Now, the issue is, and this is what we're going to see with a lot of these arguments, is a lot of that evidence came up in Alicia's trial. So it is fair game. So now the prosecution has to argue again and say why it should come in and talk about the relevance this time. I think that's what we can anticipate for the next hour as far as some of the things. Because remember, this is one of the last pre-trial conferences before the trial starts.
So it was not a part of our hearsay argument that we previously provided to the court of Bill Belichick, a coach of the New England Patriots team. There were consistent photographs of either Tom Brady or Bill Belichick posted by the defendants.
So Isaiah Chance posts photos of Bill Belichick and Tom Brady.
Yes.
Is there any words attached to the post or just the post?
No words on the Bill Belichick photo. I think hands up. I'm not sure how to describe the emoji, but an emoji on the photograph, but not words associated to that post. There were other Bill Belichick posts in the co-defendant's devices, so I have to pull them up to check for language. But to my knowledge, having discussed that with the defense attorneys, I didn't believe there was any other language that was on those photos.
And this was post murder of Charles Jones?
Correct. These were posted, some within minutes and some within the first couple of hours after the homicide.
Just for context too, Judge, some people may think Tom Brady is the GOAT of football. That's your opinion. Some people may think that Charles Jones is the GOAT of rappers, and that's somebody's opinion. And I think that that needs to be considered in its totality along.
Well, yeah, I'm just trying to figure. And so what's it relevant to?
I believe if I recall correctly, the specific testimony that was provided by that witness in trial 1 was that while he was on scene of the homicide within minutes, he logged onto social media, saw that post, and immediately knew that the poster had done it. Like that was the testimony that was provided. There was nothing specific as to the defendant's state of mind or what the intention behind posting the photo was. It was whatever the witness had observed on scene in that moment, as he was checking social media and before they were able to notify the family or the media having arrived. That was the testimony that was received, and that's what we anticipate will be the same in this trial.
Okay. So within, how quickly did the post happen after the homicide occurred?
As ChatGPT is retrieving that, listen, you know what's so wild about this is that that's all evidence that Judge Sisco let in before, during Alicia's trial. And now it has to come in again. Wow. And she doesn't remember. She's like, oh, I don't remember what happened then.
I have to check my timeline, Judge, because there are several across all of the devices that we have received.
ChatGPT is lagging today, huh? She's taking her time. Is it down? Gemini was down. No. The other one, Claude. She's taking a while to find that.
I say a Chance's post was on June 23rd at 6:13 a.m.
So is that the morning of the homicide?
Yes, Your Honor.
Before?
No, this is just after the homicide. So the homicide occurs about 5 a.m.
On June 23rd. So this is right after.
This was the
Okay.
An hour after. You gonna let it in again, Judge?
Okay. So I'm going to deny the motion in limine as to the social media post. However, grant it as to any speculation on the part of Mr. Howard as to what Mr. Chance meant.
Judge, although I can't be positive, I looked at Mr. Petraeus' screenshot, and it looks like the post was made on 6:13 a.m. And I think the murder occurred at 4:37 or 4:38, it's a couple hours.
Yeah.
Hour and a half, 2 hours, somewhere in that neighborhood.
Right. So I've denied paragraph 13 as to the post itself, but granted it as to any interpretation by Mr. Howard as to what Mr. Chance meant by it.
Okay, so she's this is why this trial is going to be a fucking shit show. All right, so we saw it on Alicia's case. We all saw it. The world saw it, right? And it came in through Robert Howard. When you want to get evidence in, you have to get evidence in through a witness. So Robert Howard and everything we're talking about right now is all coming in through Robert Howard. Okay, so Robert Howard is going to be on the stand, and this Patriots meme or whatever is going to come up again. And Robert Howard has to speak to what he thought the interpretation meant. She is not going to allow the photo to come in itself, but she is going to allow his interpretation of what he thought it meant. Here's why that's bullshit. Because we already saw it. We already saw it. Judge Sisco, come on. We already saw it.
Okay, next up, paragraph 14. Mr. Howard testified that Rashad Murphy texted him after the murder stating, "I forgive you."
And Judge, what we're talking about is not a text that the jury would be viewing. It would be Mr. Howard's testimony that Mr. Murphy texted him and said, "I forgive you," and then speculating that that is a result of Mr. Howard having been convicted of the murder of Joe Rod Adams in 2018.
Okay, State, are you going to seek to admit this?
We are seeking to admit it, Your Honor, for the same basis, the motive and intent behind the defendant having committed this crime. The testimony from Mr. Howard is that that message comes in within either the same day or the next day. I believe this is testimony at depo at trial that he receives from the defendant.
He doesn't know when he got it, really, at the end of the day. Although he does limit it to within a day.
Okay, I'm going to deny as to paragraph 14, but granted as to any speculation on the part of Mr. Howard. Okay, paragraph 15, Mr. Howard further testified that, is that Rashad Murphy?
Yes.
Okay, spoke with him after the murder and that the two discussed their respective whereabouts. Mr. Howard testified that Rashad Murphy stated he was in front of Julio's car. Okay.
Yes, Judge. Mr. Howard speculated that what Mr. Murphy meant is that he was present at the shooting. But actually, Howard admitted that Murphy never stated he was present at the scene, nor that he participated in the murder. But the context of what he was alleged to have said was he was in front of Julio's car. He previously testified during his statement that in talking about the same discussion that Mr. Murphy alleged he was present at the Truth nightclub, not at the scene of the murder. And so obviously the inconsistencies are something that can be
sussed out in cross-examination, yes.
But as it relates to him testifying that Mr. Murphy was in front of Julio's car and then testifying that what Mr. Murphy meant was that he was at the murder should be limited.
My only concern with this one is it gets a little bit convoluted. It is a part of the conversation that Mr. Howard is indicating that he's having with the defendant, whereas the defendant is completely describing the scene. You had your head on a swivel. You were looking here and there at each of the locations. And so certainly the state is seeking to admit it as identification, but I think this one, if the court is inclined as it relates to the speculation, maybe one that we ask if the court would allow that we wait until we get to that point in the presentation of the evidence. I don't know how we can slice that up, if that makes sense, based on the context of the full statement they gave for that.
I just don't want during the course of direct testimony for Mr. Howard
To draw an opinion.
to speculate that what Mr. Murphy's talking about is he was in front of the car during the course of that murder.
Okay. So again, I'll deny paragraph 14. It's admissible. But again, Mr. Howard cannot draw opinions. He can only testify as to what was said. And then that's why we have closing arguments and you guys can argue the meaning.
Did you say 14 and 15?
I'm at 15, yeah. All right, paragraph 16, Howard also testified that Rashad Murphy later told him, "It is all good, we good now." State, are you intending to introduce that statement into evidence?
Yes, Your Honor, but no objection as to limiting without speculation on the part of the witness.
Okay, very much. Very good. Then the paragraph 16 will be denied. But again, no speculation or opinion as to what Mr. Rashad Murphy meant. Okay, paragraph 17, Howard opined that social media posts referencing Don Julio were intended to disrespect toward Jones because Julio appears in Jones' Instagram handle. State, were you intending to solicit that opinion from Mr. Howard?
Not as it relates to disrespect, as it relates to Don Julio or Julio, if he has specific knowledge in this case about the fact that Julio and Don Julio are linked because of his relationship to the case, I would ask that that be admissible.
It should be. The Don Julio bottle has to come in.
And Judge,
That's
I guess,
clear.
just for clarification, Mr. Howard's not going to be testifying to his opinion that it was done in a manner of disrespect.
Right, he's just gonna say that
I
I'm,
saw bottles of Don Julio.
and to me, and based upon my knowledge and experience or whatever it may be, that is a reference to Charles Jones, right?
Understood.
Okay, so it's denied with that understanding. Again, as to paragraph 17, Mr. Howard can testify as to the facts or what he knows, but he can't speculate on the intention of the poster.
So that's coming in.
Okay.
See and judge of those that.
Okay.
category.
Moving on to co-defendant statements.
And again, I'm going to preface before the state goes any, the court goes any further. Again, understanding the court has ruled
Right.
as it relates to severance. I just want the record to be very clear.
Yes, you're not,
Have concerns.
yeah, you're not waiving any objections that you've previously made. Okay, let's see. Paragraph 25, Robert Howard stated that he had multiple conversations with Isaiah Chance in which Chance expressed his dislike for Charles Jones. He emphasized that Chance and Jones engaged in multiple social media arguments in which they disrespected one another. Are you going to be attempting to admit this evidence via Mr. Howard?
Yes, Your Honor, all of it will come in through the experts, except for one interaction which occurred between Chance and Charles Jones that Mr. Howard was the primary witness to. Otherwise, law enforcement witnessed the exchanges.
And certainly my argument has to be, notwithstanding other motions and other rulings, is that Mr. Howard not testified to that. It's coming in through a gang expert.
Right.
And as it relates to his direct interaction in seeing something occur, then of course I don't have a legal objection to that.
Okay. So to paragraph 25, it's sort of a general argument. I'm going to deny the motion in limine as to paragraph 25. However, you reserve the right to make contemporaneous objections at the time of trial. So if something's coming in through the gang expert, then at that time, if you want to raise an objection, you can, but generally speaking, it's denied. Okay, and then there's a more specific statement at paragraph 26. According to Robert Howard, Isaiah Chance allegedly stated that Charles Jones was going to die. Do you seek to admit this through Mr. Howard?
We seek to admit the conversations that occurred within the time frame of the conspiracy that's listed as it relates to these conversations, but not from before that. The motion, though, is not clear because there were conversations which occurred outside of that time frame discussing the same type of comments or threatening remarks. Mr. Howard and Mr. Chance had some type of relationship which was jovial enough for them to speak often about this issue, but there are specific exchanges which occur which indicates that there are threats on the victim's life and for Mr. Howard to kind of avoid that danger when they come to Tampa. We know that's within the time frame, regardless of whatever testimony Mr. Howard was able to give in his deposition about the specific dates, because they reference the posts that Mr. Jones made to social media of the flyers for the events that were occurring in Tampa, and that occurred on June 14th of 2024.
Judge, I would only point out that certainly we have to rely on Mr. Howard's testimony as to when he heard these things. We have no other way.
Well, I know.
And to the extent that he testifies under oath that he believed that it occurred at the end of 2023 or beginning of 2024, it would have been long before any conspiratorial timeframe. And again, as it relates to Mr. Chance, that argument can be had in another way. So generally, it occurring within late 2023 or early 2024 is a problem. And again, I would reiterate, as it relates to evidence the jury's going to hear that they can consider against Mr. Murphy, it's a problem.
Okay. So there's two separate things going on here. So let's first discuss, if I'm hearing you correctly, State, you're only intending to seek these conversations between Mr. Chance and Mr. Howard during the time frame of the conspiracy, correct?
Correct, the content of the conversations during that time frame.
Okay.
Otherwise, it is just generally the relationship between the two. Did you speak on the phone previously?
Right.
What was your relationship, but not the content?
Not the, okay. So with that understanding, that's what the state is saying. So it would appear then as to paragraph 26 and 27, because Mr. Gonzalez is alleging that Mr. Howard stated that this specific comment that Charles Jones was going to die occurred sometime at the end of 2023 or the beginning of 2024, which would be outside of your conspiracy timeframes, correct?
Agreed, Your Honor.
Okay, so as to specifically paragraph 26, that will be granted. Paragraph 28, Howard further testified that the ongoing dispute between Charles Jones and Isaiah Chance had escalated to the point that if they would have seen each other, they probably would have wanted to do something to each other. That appears to be Mr. Howard speculating. Are you going to seek to introduce that?
No, Your Honor.
Okay, so granted as to paragraph 28 is that statement. Yep. Well, 27 is not, it's just a historical fact. Okay.
The finding though, Your Honor, if I may, as to 27 and 28, they really should be together because the other remarks about Mr. Jones dying do occur within our conspiracy time period. So I don't want the record to be unclear. There are several remarks made within our conspiracy.
Right. So, okay. So as to 27, it's granted as to anything outside of the timeframes of the conspiracy, denied as to any statements made during the time frame of the conspiracy.
And certainly, Judge, subject to later potential objections, I would certainly having no reason to dispute what Ms. Isber saying. The state's going to have to, in order to admit those statements, lay a foundation as to when they occurred and whether they occurred within the conspiratorial time frame. Anything that Mr. Howard can't tell us when it happened, if that turns out to be the case, certainly I think should be excluded.
Okay. Yeah. So again, subject to contemporaneous objections at the time. But the appropriate foundation needs to be laid. Okay. Paragraph 29. According to Mr. Howard, Davion Murphy confronted him regarding Howard's involvement in Adam's murder and stated, "Bro, I'm going to catch up with you. I'm going to deal with you." This allegedly occurred at least 6 years prior to the conspiracy. State, are you seeking to admit this?
We are seeking to.
So as we are going into this, y'all do me a huge favor. Type in the little gaming channel in the chat. TLGC, we finally going to court on this one. We are fine. And y'all know Judge Sisco doesn't play. For anybody that's coming in, type in TLGC. He has become the new stream sponsor of this stream. We have a trial starting this week. We're rolling into jury selection, but this is what we're doing in May. You know, these are one of my favorite things to do on this channel is actually stream trials, right? So we got all of that going on. The judge is denying things. What's happening right now is you're hearing a ton of motions in limine. And one of you guys asked like what that means. A motion in limine is a motion that happens before trial where certain things are talked about that is either kept in, meaning that it comes into evidence, or kept out, meaning we don't want the jury to see it, okay? It's difficult because a lot of the stuff that they're discussing right now came out in Alicia's trial. I want to know if we're going to hear about Sean's mom, Sean Gathrights' mom. But thank you guys so much for showing TLGC some love. And thank you, brother. You already know you keep you keep my channel going. And like, you know, sometimes it gets tough as a content creator. You know, sometimes you have to deal with personal stuff. I had to take the week off last week to deal with some family things. But now that I'm back right on time so that we can start this and people like TLGC keep this work going, you know? So thank you so much, TLGC. Thank you for you guys giving him his flowers We are just at the hour mark. We've got about a half hour to go. This is the last hearing before the trial starts this week. Let's go back on in.
Admitted, Your Honor, for identification purposes and for motive evidence, these statements were made specifically as a part of this quote as well, following Mr. Murphy's mention that Spaz, or the person that Mr. Howard was incarcerated for killing at the time, was his relative. And so he's shouting that at Mr. Howard at the time. Mr. Howard also being present with the victim in that parking lot on this evening would be a basis as to why we're seeking to introduce this.
Okay.
It occurred allegedly 6 years prior to Mr. Jones' murder. Number one, again, just so we're clear, there is problem number one, its admission of a statement 6 years earlier and how it might affect the jury as it relates to Rashad Murphy, since we are not severed, number one. And number two, it again falls, based on the prior arguments, far outside of the conspiratorial timeframe.
All right, let me think about that one. Reserve ruling. Okay. 30 is just a statement of law, paragraph 30.
One more thing, Judge.
Sure.
Also, as it relates to the fact that there are two Murphys here, and these Murphys are cousins.
Right.
I think there's a even more complex and complicated issue in allowing that statement to come in and how the jury may perceive it, and its prejudicial effect outweighing any probative value.
Okay. Thank you. I reserve ruling. 30, paragraph 31, Howard attributes several statements to co-defendant
Can we
Isaiah
talk about,
Chance.
Judge?
We've already discussed it. Okay, same ruling. 32 is just a legal
Context,
argument. Okay. I think that takes care of
It
your
does,
motion. Okay, so I'm going to think about
7A.
7A and then paragraph 29. Okay, I'll let you guys know.
Thank you, Your Honor.
Sure. And again, when we talk about the severance issue, again, just to clarify, we don't have a brutal problem here. And then the only issue would be if there's evidence that would, quote, improperly influence, close quote, the jury, with evidence that would be admissible against one or more co-defendant and not all of them, which is kind of an amorphous standard. So it's kind of beauty in the eye of the beholder. So that would be the determination, whether that evidence would rise to the level of improperly influencing the jury.
And Judge, it goes without saying that the state would not be opposed to a limiting instruction from this court, specifically with instructions to the jury as to which defendant the evidence applies to at the time when we introduce those portions.
Sure, I understand. And it is a different, I did find really an abundance of caution, the two statements or the two text messages that the state agreed not to introduce were I think it was 2023, a set of text message exchanges between Isaiah Chance and Alicia Andrews. While those, in my opinion, are admissible as to Miss Andrews and Mr. Chance, it does predate the conspiracy. So in abundance of caution, those should not come in. The state agreed. The other one was, I guess, the celebratory comment made by Mr. I think Davion Murphy that was sent to Sean.
Judge, I don't believe we know which Murphy
Right.
specifically sent it, but it's
Okay.
signed Murphy.
Right. So for those reasons, and including the fact it was post-conspiracy and an abundance of caution, I didn't think it should come in as at a joint trial, and the state agreed. These statements that are made by the defendants during the conspiracy timeframe in particular are distinguishable from those that I thought should be excluded in an abundance of caution. As I'm trying to not tiptoe close to, quote, improperly influencing, close quote, the jury, as that phrase has been utilized in specifically second DCA precedent.
Judge, and just so the record shows, notwithstanding the court's ruling, as it relates to the celebratory messages that are not coming in, there was testimony from Detective Ramos that, in fact, the witnesses he spoke to indicated that they didn't know Rashad Murphy. It was Davion Murphy that they were aware of, and that that's who they believe the text messages were sent by.
Right.
Just
So we
we're-
had two issues with that, with those messages. One, it was post-conspiracy, and two, the foundation of who actually sent it, which of the Murphys is less than crystal clear, right? Right. Okay. 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 So, and then the other motion was with regards to the Andrews verdict during penalty phase.
Yes, Mr. Harmon filed that, I believe yesterday afternoon. He is out today, but I said that I could cover it. Do you want to handle that now, or I don't know if you received it or not?
If I received it, I haven't seen a copy yet. So do you have a copy I can look at? Okay, thank you.
And Judge, we did briefly touch upon it. I believe that Mr. Petratus had filed a judicial notice of the verdict of Alicia Andrews, and we had spoken, and I think that you had previously said that obviously it would not come in during the guilt phase, that it did not have a relevance. I think that Mr. Petratus had made some indication that he thought it might be relevant for penalty phase. And I think that is Mr. Harmon's objection. He filed a formal motion in limine objecting to that, as it would be improper and have no bearing or relevance to the jury's decision with regards to mitigation. It's improper character. There's no reason or way to tell this jury why the jury in Alicia Andrews made the decision that it did. There could be numerous, a myriad of reasons, including mercy, jury nullification. We don't know why they made the decision that they did. So what happens in one defendant's trial, verdict, or sentence doesn't have a bearing, or should not have a bearing
Interesting.
in the current defendant's penalty phase. And so that was the basis of his motion.
Well, and it looks like there may be precedent, United States Supreme Court opinion, Lockett, right?
Yes, there was some case law that he filed as well
Okay.
in support of his position.
Okay, so I tell you what, I'm going to take it under advisement. Let me take a look at this Lockett case.
So she's being very careful this time. So for those that are just coming in, Alicia's stuff is on hold right now. She was about to be sentenced in December. That was put on hold because this judge, Judge Sisco, who's about to preside over the 4 boys, the remaining defendants left in this case, has been removed from Alicia's case. So Alicia is still facing sentencing. She has filed for a new trial. Jeremy and team are fighting for that. But this case that we're watching right now is going to go first. So Alicia has a court date in May, but this case is going to start before that court date. And what you're seeing is so much crossover because a lot of the evidence that they're talking about right now is evidence that came in through Alicia's trial. Okay, it's we already saw it. So a lot of it's going to be duplicate, but I am curious to see what the new stuff is going to look like too. Because with 3 of these boys facing the death penalty, it's going to be interesting. Let's go back on in.
And then, Mr. Petratus, do you have any additional, or does anyone have any additional case law, or do they want a chance to submit it?
I don't have any additional case law right now.
Okay, so I tell you what, I'm going to take it under advisement. I'm going to look at Lockett.
Sure, could we have a chance?
Yep. How much time do you need?
Briefly address something on that.
Sure.
I just looked out the motion this morning, but I think we're just dealing with sentence, not involvement, correct? Because
Correct.
I think that Alicia Andrews' involvement in a penalty phase can be compared to another particular defendant's involvement. But I'm trying to make sure that the state's motion is only dealing with sentence, not Alicia Andrews' actual involvement in this case.
Well, it says specifically in the motion, the subject matter in question is any argument comparing or regarding the verdict rendered by the jury to the Alicia Andrews case to the defendants or otherwise arguing that fact as mitigation.
The point, exactly, the point I'm making is that I think that her involvement, any defendant's involvement, which can be a problem when you have multiple defendants, but the involvement of one defendant versus another can be relevant for a penalty phase.
Okay.
Not verdict, as in the Andrews case maybe, or the sentence, but certainly one person can be more culpable than the other. And again, the problem is suggesting that maybe one defendant should get life and another defendant should get death.
Okay, so I'm going to give you guys a chance to research the issue and submit case law. Okay, so how much time do you need?
You have at least a week, Your Honor.
Sure. Okay, so I tell you what, I will give you guys until Friday, April 10th to submit any case law to me on this topic.
All right, so that issue is still outstanding till this Friday. Jury selection starts on Wednesday.
Okay. Any other motions we need to discuss?
Your Honor, as a part of the state's response from this morning, the court had previously asked the parties to submit to the state any additional YouTube videos they intended to use or additional items of evidence that the court needed to consider. So the state did also address those things. I can tell the court that I've reviewed the videos that were provided, and the state does have some objections to those videos. I know Mr. Chance, on behalf of Mr. Chance, that there were 4 videos provided, and on behalf of Mr. Murphy, there were 4 videos provided.
Davion Murphy.
Davion Murphy. I will defer to the court as to how we address those, or if the court just wants to hear the state's objections as to those.
But do you have them identified?
Yes, and with a link in the event that the court or the other parties wish to see that as well in the motion.
But you haven't filed a motion in limine.
I have filed a motion, yes.
You have?
Yes, Your Honor.
Okay.
I filed it this morning because we received the defense to this motion in limine on their videos yesterday.
Okay. Well, can I take a look at your motion?
Yes. May I approach, Your Honor?
Sure.
Okay.
I just emailed the judge. She wants me to print this with you.
Okay.
The death penalty is on the table for 3 of them.
Okay. All right. So according to this motion, state wishes to keep out, as to Isaiah Chance, a video titled List of Dead Ops that was posted on YouTube. A block party invasion went to Young and Ace block. It's a YouTube video. 3, God Don't Know by Julio Foolio. And number 4, Demigod by Julio Foolio. So are any of the defendants seeking to actually introduce these, and why?
These would be, these were said, somewhat in abundance of caution, but these would be rebuttal, depending on what is testified to by some of the state's experts, the gang experts.
I see.
And it, they would be authenticated through that expert, if at all. It may not be necessary depending on direct cross-examination. And possibly only if it needs some still shots from some of these videos.
All right. So you're not intending to utilize these, and in your case in chief, seek to admit them in your case in chief. It would just be potentially as impeachment or rebuttal as to the testimony of the gang expert.
Correct, John, for a variety of reasons, based on gang certification and issues with Mr. Jones.
Okay, so then as to these 4 identified videos, I'm going to grant the motion without prejudice to revisit. If you think that you actually need to introduce them, we just need to talk about it before you do it.
Yes, sir, I understand.
Okay? But generally speaking, the videos are not to be referenced or discussed in front of the jury until I've given permission for any party to do so. And then as to Davion Murphy, the videos listed are When I See You by Julio Foolio. Again, the list of dead ops. YouTube video Certified Killer by Julio Foolio and God Don't Know by Julio Foolio. And why is Mr. Murphy going to seek to introduce these, or what are you going to do with these?
Would be the same position as Mr. Chance, Judge, becomes.
If you think they become relevant, then you would seek to introduce
That's
them.
correct. That's the court just to,
But you're not going to be submitting them as you don't anticipate at this point as part of your case in chief.
correct.
Okay. So that'll
I
be the
mean, like, why are you I get to see why they're introducing it. I do have Folio's channel up on this other monitor here. And some of these songs, like I think Certified Killer is just the audio version. So I don't know what we're gonna get from just the audio versions of these songs. Demigod, it does say official music video as well. So we'll see how they handle it. It's interesting though that Young and Ace came up as well, but it's like Young and Ace is not in this trial and Folio is not here either. But we'll see how the defense teams want to bring that in as far as evidence.
same ruling. Generally speaking, these videos 1 through 4, as to Davion Murphy, the state's motion is granted. However, without prejudice, to revisit, and during trial and defense, you just need to confirm with me ahead of time before you start showing them or discussing them in front of the jury.
That's fine.
Okay, very good. Then we've got unrelated officer conduct. Counsel for Davion Murphy has filed a notice of intent to rely and listed a witness and records from the Jacksonville Sheriff's Office to include the personnel history of Detective Craig Griffin and Trey McCullough. Are you going to actually seek to utilize these records as impeachment?
Yes, I believe that's Ms. May's motion.
She filed a motion as to these?
Yeah, I thought that was what it was correct.
Well, 'cause I don't have that motion in front of me. So did Ms. Tumay, did Davion Murphy file a motion in limine specifically to include this information?
She did not. She sent us an email with a notice of her intent to rely on the information, and she did file an amended discovery list with instructions that she would seek to introduce or admit the following videos and evidence, and then listed the witness as well.
Okay. So, Mr. Sonardi, is Ms. Tumay, is she handling this argument, this issue?
I was not aware that Ms. May was not going to be here. I'm really not in a position to argue that motion.
No, I understand. I honestly would like to see what we're talking about here, as far as what the actual evidence is. So,
We were not filing, Your Honor, but I do have 2 copies of the investigation history. I do not have copies of the civil lawsuits that were filed against the Jacksonville Sheriff's Office for the court because they were pretty lengthy. But I can provide these copies.
But I don't think that was actually filed.
okay. So here's what we need to do. Are you able to contact her this morning? Mr. Sonardi?
Right, I got her number on me, so.
Governor, if it's okay, I have, warrant in Polk County, if I can.
Yes, you're free to go. So
All right.
I tell you what, let's do this, Mr. Snarty, let's just take a, we'll recess as far as Davion Murphy, and I'll give you a chance to, because we're gonna need to set another date, because I'm gonna need to actually physically take a look at what these records are, and we need to have further discussion on this, and whoever needs to be able to argue the motion. So why don't you find out her availability for the remainder of this week and Monday and Tuesday of next week, so we can get that done. Are there any other issues as to Rashad Murphy, Sean Gathright, or Isaiah Chance?
No, Karen, the only thing, and this may not be the time, but I know we were talking about deputies. They want to talk logistics as far as how we're going to plan on fitting everyone.
I was gonna bring that up, Judge. There's a small army on the side of the fence.
It's only about half of us, I think.
Okay. Well,
You're just gonna leave that up to us and the court staff?
yes.
Do you have anything you don't want? Because
No, I really don't. As long as you guys can get to the podium without having to create a distraction, that's all I care about. So
and certainly having ingress and egress without
yeah,
the staff being concerned about.
correct. So I do think anybody that's not going to be speaking on the record, okay, staff that's not going to be speaking on the record, do you want them in the well, or are they okay in the audience, or what do you think?
Judge, in previous experience, I could tell the court that for me personally, my investigator is critical.
Okay.
In a number of different ways in a trial this big.
Okay.
So I would suggest to you that I would need my investigator at council table.
Okay. So how many people total? You have yourself, Mr. Hernandez, your investigator. Who do you need at table in addition to your client?
Mr. Hernandez, myself, and the investigator.
Okay, so you need 4 people.
Correct.
Okay, Mr. Sonardi, how many people do you need at council?
So now we're just going through things so we can get ready for trial. Basically, same thing we saw in YSL. We're going to have a sea of defendants, but now they're going through who they need at each table. So we just started with Rashad. They will have a 4th person at Rashad's table. Let's see what we see with Davion.
Table.
Your Honor, obviously, myself, I'd like to have my investigator, but it's possible that she could sit behind me, so she's not. at the
Okay.
table.
Could your investigator sit behind you, Mr. Gonzalez?
I'd rather not, Judge.
Okay.
I mean, unless it's a crisis situation, because he does work very closely, not only with me,
Okay.
but with Mr. Murphy.
Okay, so they
And
want,
I would like Scotty Sinardi, the other.
Yes.
attorneys with me.
and Mr. DeLauder.
I don't know.
Your Honor, considering I'm the smallest fish in the pond and the last one on the totem pole, I'll go wherever I need to facilitate.
We could-
It'd be nice to be at the table.
Right.
But wherever I.
Need be, we can throw you off the island into the audience, right? Okay. But 5 preferably in a perfect world. Okay, Mr. Wise?
Here we have Ms. Finkelstein, you may recall Mr. Mendez is 3rd chair counsel as well. He's been here for some of the proceedings. And then I would like our investigator slash mitigation expert, at least during jury selection, if there is a definitive phase.
Okay, so 5.
Yeah.
5 for Davion,
Okay, Mr. Petratus?
5 for Sean,
5.
and 5 for, wow, Isaiah.
Okay. Okay. Ooh, okay. Okay, very good. So we are,
Not very good at math. I think that's 19.
yeah, okay. That's fine. We'll figure it out. Maybe we need to change the setup as opposed to an L shape, because once we get the jury in here, it's going to be much more important that you all are facing the jury than me. So what I may do is have the bailiffs, we'll work on it, but maybe move the tables so they're actually facing the jury, and during jury selection, turn them so they're facing out towards the jury, something like that. Okay. So we'll make it work. We'll figure it out.
Your Honor?
Yep.
Hi, I'm Nixon, I'm the investigator. I have Deborah, told me, she said she is available April 2nd in the afternoon at 1:30.
Okay. State.
Does that work for you?
It is for me, but I don't know, does it work for the state?
Sorry, what was that?
April 2nd at 1:30.
Could we make it 2 o'clock?
Okay for the state.
Okay,
I will say yes on behalf of Mr.
all right. So, and then, as to,
Judge, I also think Ms. Toomey, just from speaking with Ms. Toomey and myself, there's one other matter that we may not be in total agreement about, the defendant's reported statement that she may want to bring to your attention. We have worked out most of it.
as to Davion Murphy.
Yes, ma'am.
Okay, that's fine. So I will hear those matters at 2 o'clock on April the 2nd. If the other defendants wish to be present for that, you're welcome to. It's up to you. Mr. Gonzalez.
Nothing further, Judge, and thank you for the offer. I'm not sure we'll be attending, but
Yeah, that's fine. So for now, I'm going to tell the sheriff's office not to transport your client. But if something changes,
that's fine, Judge, yes.
okay. So do not transport Rashad Murphy on April 2nd in the afternoon. As to Mr. Gathright, Mr. Wise, does your client wish to be here for those motions?
I have a conflict, Your Honor. Mr. Gathway's fine with waiving.
Okay, that's very good. So do not transport Mr. Gathright. And as to Mr. Chance, Mr. Petratus. Okay, very good. All right,
The only one that's gonna be said is
Davion Murphy. Okay. And that is so that I can hear, I know you just gave me the motion. I know you just gave it to me. Now I can't find it. The motion with regards to the personnel files of 2 of the detectives from the Jacksonville Sheriff's Office.
And any objections from the defense, if we just as a courtesy, just print out the exhibits that were provided to the state and hand deliver them to the court at some point today? The attachments that were all sent to us with this personnel file, those lawsuits and such, everything we attached. Is there any, sure. Is there any objection to us providing that in advance to the court for review before Thursday?
No.
Okay, and for the record, it's the state's 7th penalty phase motion for order in limine. No, that's the,
Yeah, that was the one with,
that's the one I gave you all until, gave
April 10th.
April 10th to the defense to submit any case law. Oh, okay. So it would be, we're going to, as to Davion Murphy, the motion for, it would be part of the state's motion for order in limine regarding improper character evidence as to unrelated officer conduct. That's what we will hear Thursday, April 2nd at 2 o'clock. Yeah, let's just go ahead and use in my regular courtroom for that since it's just one of the defendants. All right, so please let Ms. Toomey know, Mr. Sonardi, that I'm going to hear that motion in my regular courtroom. Okay. Okay. Is that it for today? Oh, and on the raw data, I need, how quickly do you think, how much time do you think you need for your experts to get that information over to the state's expert? A week? What are you asking for, state?
Judge, I think that as long as they get it to us within the week, I think that should give Mr. Harmon's experts the opportunity to be able to review it. I don't believe they have set Mr. Harmon's expert witness for deposition yet either, so I think that that's fine.
Judge, I probably should have not let Mr. Hernandez go, but, and I don't, because I don't know the status of the way that train is rolling, certainly I'm gonna just defer to whatever the court thinks.
All right, I'm gonna say by April 8th, by the time we begin jury selection. Okay?
Judge, and just, that reminds me, I know that, Mr. Petridis listed an expert, a gang expert as well, that we attempted to take the deposition of, but that expert is Dr. Leap, had not actually finalized her opinion, and she said that she would have it finalized by the 8th, and we would be able to take her depo in a couple of days from that time frame. I just wanted to put that on the record, just to make sure that she has her finalized opinion by that date.
Let her know, we scheduled it for April 9th at 5:30. And I let her know that. She responded, she's under the weather right now.
Okay.
Won't be a problem for April, but I did let her know that double date, and she has
Yep.
sent me a pushback.
So that, what's the expert's name again?
Dr. Leap.
Leap?
LEAP.
Okay, Dr. Leap's report needs to be submitted to the state by
Looks like we have.
9 a.m. on April 8th.
I was
Okay.
gonna do a physical report.
Oh, is she gonna, does she have any material she's gonna rely upon?
Yeah, she's relied upon,
The state's
the state's
evidence.
discovery.
Okay.
She will, but by the depo date, she will, when she gets the depo, she will have to have.
Okay, so she's not gonna issue a report, so,
That's
But-
fine, Judge.
okay, very good.
Does I have a question?
Yep.
The state's motion regarding the improper character evidence.
Yep.
As to, you got the right?
This just says to Davion Murphy.
Right, because I thought you had said it was.
Well, no, part of it was.
Part of it.
So I've ruled on the motion for order in limine regarding improper character evidence and the state's response.
Mhm.
I ruled on the video portion.
Okay.
Okay, that's I've ruled on. I've granted the motion without prejudice to revisit if necessary. And then unrelated officer conduct as to that part of the motion, that's being set for hearing or continued for hearing for April 2nd. Okay? Okay, and I'm going to hold on. Ms. Ismer, you gave me a copy of the state's response and motion for order in limine regarding improper character evidence. I'm just going to hold on to that. That's okay. Okay. Anything further? Okay. So, if you don't hear further from me, or if you do need anything, by all means, make sure you contact me and let me know. I'm available to do whatever I need to do to help you guys get ready for trial. So for those other than Mr. Davion Murphy, if you don't need me in the interim, then I will see everyone. You need to be, I would say, courtroom 1, I would be there by 8:30 in the morning. So as soon as jury services gets 175 people to walk through the door, they will send the list over to us with the names and numbers. You guys can begin filling out your seating chart. Okay. So be it in courtroom
Name
1.
and number only, we're not.
Only.
Jury sheets.
Yeah, because at least half of those people are going to be gone by the end of the day. So there's no point reviewing juror slips for people that are going to be discharged. There's no reason. So, and then you'll have more than sufficient time you'll have over the weekend to begin reviewing the slips for any and all that are coming back for phase 2 voir dire the following week. Okay?
But we'll be trying to piece in here, just jury selection.
Correct.
on one.
Just jury selection in courtroom 1 because I need the lobby. Okay? Okay. Very good. Thank you all.
All right. So, chat, the word of the day, as Anthony puts it below, is okay. We are going to have an interesting few weeks with Judge Sisco presiding over the murder case of rapper Julio Foolio. Now, here's what's going to happen. The case officially starts 2 days from now, so we are on jury selection watch for the week. I don't know if Law and Crime is going to be showing us what happens in jury selection. It's a pretty slow process. It looks like the pool is going to be 170 people in the Tampa Bay area. Now, what happens is those people come in and we start picking them off one by one, right? What happens is the defense team gets to ask some questions, prosecutors get to ask some questions, because whenever you have somebody on the jury, you want them to be fair and impartial. You want them to be made up of a jury of your peers. That did not happen with Alicia Andrews. So we are going to see that happen here. And they're going to start selecting the people. This is a very important trial because 3 of the defendants are on trial, not only for like they're facing the death penalty. So they can either get death or life. It's not something you see every day, right? Also, what's interesting about this is you have 4 defendants. Typically, whenever we watch trials on this channel, we see 1 defendant. But here, we haven't seen a multi-defendant situation since the YSL case. So this could take us some time. They're going to do this in 2 phases, all right? So this week, we start with phase 1. If they live stream it, I will be here live so y'all can hear how they're picking people for the jury. It's a pretty tedious process, but we'll see if they stream it. Now, Law and Crime historically will go live on opening statements. Sometimes they do jury selection. We saw it with the Donna Adelson case. They don't always do it, but sometimes they do it. So we will be watching on Wednesday to see if they put something up, if there's cameras in the courtroom, and we can hear what's going on. So that is phase 1 this week, starting on Wednesday. Phase 2 next week is they're going to reduce that group further. Because this has a death penalty on the table, they have to be very careful with who they select to be on the jury. Remember, you have the interest of 4 different defendants. This isn't just 1 defendant that's facing trial. You have 4. And each of them might have different culpability because one of them is not facing the death penalty, okay? So we're going to see how all of that plays out. Now, what she does do, Judge Sisco here, she did it in the Alicia Andrews case, is she gives very firm timelines. I thought maybe she would be flexible this time. Hell no, she is not. She said, all right, you know, she went to all the defense attorneys and she's like, okay, is there any date that you need to be done? One person says May 8th. She's like, oh, we'll be done by then. Another person says May 15th. She goes, we'll be done by then. She gave Alicia Andrews 7 business days to get this trial closed, okay? Now, in this one, she's doing the same thing. She's given these boys 8 to 9 days. So if we start on the 21st to hear opening arguments, we might be done by May 1st. I mean, shit. We might be all done by, May 1st. And is there anything wrong with a judge giving a timeline like that? No, I mean, I do think in this country, we do need to give, like, people do have timelines. We saw it in Amber Heard and Johnny Depp, each side. And that Virginia case was given a certain time allotment to present their sides of the case. And YSL, it was the longest case in Georgia history. But at the end of the day, even when you had some of the defendants from the group of 6, 4 of them took deals, right? And 2 of them remained and fought their cases. The 2 that stayed on, they were done in like a week. And it's so funny because the October 31st date comes up because that's the day that Young Thug accepted his plea deal, right? Alicia Andrews got at least, her verdict on Halloween as well, October 31st. And now a few months later, we are seeing what's going to happen with these 4 gentlemen. She's not giving them a lot of time, but they have 8 or 9 days to present their case. Could it end earlier? Yes. Could things happen? Yes. But Judge Sisco, we all know and have seen her. She is presiding over this, not just with 1 defendant this time, but with 4. All right. A lot of repeat evidence was talked about in this hearing. A lot of the evidence that we saw in Alicia's case is going to be back in front of us again. And we're also going to see new evidence. The thing is with Alicia, it was like, okay, is she really central to the situation? But now you have these boys on camera, Tesla cameras. I want to see the plotting. I want to see the planning. Court of public opinion, I want you to see it too. Are these boys cooked? Are they cooked more than Alicia? Because what was interesting about the Alicia Andrews case is that you, dear viewer, court of public opinion, some of y'all stayed strong. Some of y'all were standing on your square. But some of you changed your position on guilt throughout the course of that trial. So I'm looking forward to another one. I think this is probably the first one that we'll be doing on this channel for 2026. So it should be interesting. But yeah, it's going to be crazy. I mean, Cheyenne says, I love watching them pick a jury. So interesting. Yes, because here's what happens, Cheyenne. I love that you mentioned that, because sometimes you pick people in the jury, and what happens is once the trial is over, those people get to speak out and do interviews and talk about their experience. So jury selection for this one is tough, especially in the state of Florida, where the death penalty is on the table. Coming to our poll right now, I said, are these boys cooked? 82% of you said yes. 6% of you said no, they have a chance. And 12% of you said, I am not sure yet. I do owe you guys about two t-shirts. I'm going to try to hold on to them a little bit because I want to do it when more people are here, maybe on opening statement day, give out some memberships, all of that fun stuff. When these trials happen, this community really is amazing to trial watch together. I wish we caught the Afro Man one together, but honestly, he is copyright striking everybody for them damn songs. So it is, it's happening. You do it live, but then the aftermath is not so fun. Let me read some super chats and then I'm come out of here. Shout out to Deanra, been with me for 2 years since the YSL days, says just bring the potato salad because they cooked. I mean, how do you defend this? How? Like how? These defense attorneys have a tall order, but I think one of the biggest things, and it might be one of the bigger trials that we see, because the death penalty is not what we saw in Georgia for YSL. This is very different, you know? So we'll see what happens. But thank you, D. Shout out to Crying Freeman. Hits me with the 2, says you gotta cover Pooh Shicey. Love you, AV. Yes, that is another one. Now that I have a little bit of time before we go to trial, I will absolutely do a short synopsis video on that situation, and also this one to catch people up, because some of you guys are not familiar with the Alicia thing, but I do think it's important that you're ready before we go to trial so you're all up to speed. I will even look at some of the problematic witnesses from Alicia's trial that could be an issue this time, right? Some of the evidence that wasn't problematic for Alicia, but for these boys, we'll see what happens, right? Shout out to Lucretia. Good to see you, girl. She has been with me for 20 months, also almost 2 years, says, hey, AV. Yeah, all my day ones are coming out today. Shout out to Nurse Janice, been with me for 22 months as well, says, sending love from the UK. Glad to be back. Yes, for those that are joining late, I did take a week off last week, but we have a lot of things going on. So we're getting all of that content out, because whenever trials happen, I tell my family, I'm like, nobody bother me. I'm locked in with my people. We just going to court. We're just watching court for 8 hours a day for a few days. It's a long haul, but we're looking forward to it. So good to see you back, Nurse Janice. D hits me with another 5, says you can't just go shooting stuff up without consequences. You got Foolio, and this is the cost. Yeah, and I think his mom is working on a documentary right now that should likely be released around the time that this trial starts. So I'd love to bring her back and speak about that a bit, you know, just to see what it's been like since Alicia's trial, and then come over here for this one. Now, we were supposed to do an interview together around the time of sentencing, but Alicia never got sentenced, so we didn't finish it, you know, but I think she'll come on for this one. She's a sweetheart. Shout out to Trainwreck Entertainment, been with me also for almost 2 years, says I'm here supporting AV and I support you. Trainwreck, thank you so much for all the love and support over the years. D with the 2 says Judge Sisco looks like this ain't going to take long. Yeah, she's like, this ain't gonna take long. She is. She said it multiple times, and she did it with Alicia. And the defense team felt like they weren't given enough time to defend their case. And ultimately, Judge Sisco was removed from that case. Not while the case was going on, but after it was in the appeals era, right? So in that appeals level, she was removed then. So Judge Sisco cannot sentence Alicia, even though she was the one that watched everything happen and absorbed all that information, instructed the jury, just like what we're about to do all over again. All of that happened. But thank you, D. Shout out to Hollywood, who gifted 1 membership. I think he gifted another one. Thank you, Hollywood. Always appreciate you popping up and hanging out in the chatter hood. Senator pops in as well with the 5, says AV. Senator, good to see you, brother. Of course, you have your stream sponsor, the Little Gaming Channel, sponsoring many streams, multiple trials on this channel as well. And I am always excited when we get into another one. I thought we were going to have a double header this month with Courtney Clenny and this trial, but it is likely we're just going to do this one for the month of April into May. I think, oh my God, Keefe D about to go on trial too, like for murdering Tupac. We might get that this summer. So there's so many that are happening, but we've been waiting for this one. It's actually happening pretty fast. Girl loves basketball. I see you change your name, sis. Thank you. Been with me for 19 months as Chatterhood. What's good? We all here. We all out here. We're waiting for another trial. It's starting. Thank you so much. Hollywood gifted that other membership. Thank you. I think I saw Money Cash that received one of your memberships. If you receive a membership from somebody in chat that gives it to you, say thank you. That's what we do over here. Belfast BMAC across the pond, been with me for 16 months, came around during the Karen Reed time, says Kate Bird, let's get it. Oh yeah, I remember, I think you have some kiddos that are CVs, so good to see you. Anna has been with me for 15 months, says miss you AV, can't wait for the trial. Yeah, this is gonna be fantastic, guys. It's been a while since I trial streamed, so I'm really, really looking forward to it. You guys know we come up with jokes and every piece of merch, all the jokes on this channel, they really come from you. They come from all of you guys. So when you're in the chat cutting up, you might see some fan favorites, people that are repeatedly here, and you know who the jokesters are, but it's always a good time. And it also does get you through your workday. So y'all come hang out with us while we watch this trial. I mean, as far as I know, these boys are cooked. They are. I mean, I don't know. But at the same time, it's almost like a football game. You never know what's going to happen. We've seen it with Alicia. Half of the people in Chatterhood changed their minds. They were like, oh, she's cooked, she's cooked, she's cooked. Then it went from like 80% cooked to like 50%. And then people started switching. And I polled y'all every day. And it was a lot of fun to do that because the data doesn't lie. It shows that this is how y'all are feeling. Imagine how that jury feels, right? And then they had to deliberate and returned a verdict that day. And they did. So it's interesting to see what's going to happen this time around. But yeah, guys, I'm going to just start getting ready for it. It's going to be an amazing next few weeks. But yeah, there's always some stuff that happens on trial. I am the most excited to see Sean's mother on the stand again against the prosecutor, who I like to call ChatGPT. I want to see round 2 with them. What is that going to be like, right? Shout out to Scooby popping in with the super sticker. Thank you, brother. Good to see you. Good to see you. But yeah, guys, I am going to head out of here. If you have not seen it, we are still keeping track of politics as well for all of those people that are watching the Fonnie Willis, Nathan Wade story. We dropped a video before I went live earlier today. So please make sure you check that one out. For those that are interested in Foolio, we are Foolio Central this month, okay? This month, this is the place to come back to. So make sure you subscribe, you like, you comment, you engage, because this is where you're going to get those updates. Anywho, I'm going to get out of here. Y'all stay safe out there. See you in the next one. Bye.